All right, you may be seated. Good morning, ladies and gentlemen.
Good morning.
All right. So ladies and gentlemen, the jury trial is going to be live streamed on YouTube, so I need you to help me maintain your anonymity. If I have you leave the courtroom, I want everybody to make sure, you see that bottom square on the screen? That's what they see on YouTube, what's in that bottom screen. If at any time that bottom screen is not at the floor, like I'm going to change it and that door is going to be in the bottom screen, that's the door that you're going to leave out of. If I say the jury is going to go out, but you see that door in this screen, say, Judge, hold on the door, so I won't let the people see you going out, okay? So see, right now, we can see the officer standing at that door. I don't want the door to be in view once, when you're leaving and going. Additionally, we are getting ready to, receive opening statements. I will give you those notepads after opening statements. Remember that opening statements are not evidence. So you just listen to what each attorney says, and then after they conclude, I will give you your notebooks. There is one matter that I'm gonna have to take up, and I'm actually just gonna do it in your presence. It's the trial that was supposed to start today. I need to adjourn it. So I'm not gonna have you leave out, but, I will handle one matter on Zoom as soon as Mr. Hayes or somebody logs in. Okay. Oh, because I told him 10:30. That's why. But council is early. That's what it is. I didn't tell him 9:30. I told him 10:30. So he's all right. Okay. Council, are you ready for an opening statement?
Yes, sir.
You may proceed.
Good morning, members of the jury. As I said, my name is Philip Henderson, and I'm here on behalf of the people of the state of Michigan. We talked a lot in Dyer about a lot of things, but the evidence in this case will show that this case is about an elderly lady who got punched in the face multiple times, who had nails dug in her chest, and who was forced to the ground all over a parking spot. That's what the evidence in this case will show. The evidence will show that in February of 2018, she was visiting a friend. She brought him back from a place, and they were in his apartment together. That she heard yelling and cursing and screaming from the floor above, and you'll hear that evidence will show that person was Devontae Jackson, the defendant. Evidence will show she was upset about a parking space. So Ms. Ethel Drakeford, the complaining witness in this case, ascertained that she was complaining about a parking spot. So what did she do? She went outside, she moved her car, she vacated that spot so that the defendant could have the spot. But when she tried to go back inside, Ms. Jackson had already beaten her to the door and tried to keep her out from visiting a friend. This was a 4-apartment building, 2 below, 2 above. Mr. Hughes' apartment was below. And when that door couldn't close on her, when Ms. Draper had put a foot inside, you'll hear the defendant dug her nails in Ms. Draper's chest, and she started striking Mrs. Draper about the head and face. And in desperation, she did the defendant's finger. But that didn't stop it. You'll hear that somehow this tussle made it into Mr. Hughes' apartment. And it did not end. This attack did not end until a friend of the defendant came and pulled her off a misdemeanor. This case, you will hear, the evidence will show, is about an elderly lady who got beat up over a parking spot. The evidence will show that she, the next day, took pictures of her injuries to her head and her face. And when you consider her testimony, when you consider the pictures that we intend to introduce, we consider all the evidence in this case, people believe that you will bring back the only fair and just verdict in this case. And that is on count 1, assault and battery, a verdict of guilty. Thank you.
Stephen, I apologize. Give me one.
Okay.
Is this coming here?
Madam
Like,
President,
he might get stopped. Okay. Good morning, Mr. Hayes. Thank you for zooming in a little early.
Good morning.
Council came early, so I wanted to go ahead and get it out of the way before I got into the testimony.
he said he was on the job.
Oh, well, can you come off of one? Okay. Mr. Hayes and Mr. Babish, turn your cameras off.
He's coming.
Oh, never mind. Okay. Thank you, counsel, and you can just stand, well, just come to the podium. You can come. And
Sorry, Judge.
that's okay, I know how to Zoom like this, I'm glad I don't have to deal with it at the moment. Okay, I'm ready on case number 224487001. The people of the state of Michigan versus Tessa Marion, Opie, maybe? Matiku. The defendant is charged with one count of gambling, disassociated person. Today is the day set for, trial. Appearances, please.
Peter Torres, P68242 here on behalf of Mr. Matiku.
You went first. Mr. Babish.
Good morning, Your Honor. Jake Babish on behalf of the people. I'm a third-year law student at an accredited law school in good standing, requesting your permission under Michigan Court Rule 8.120 and under the supervision of Assistant Attorney General Robert Hayes.
Permission granted. I actually. But come on, work with me. Okay, today is the day set for trial. Mr. Matiku is not here. I am gonna waive his presence, and you can kind of tell him not to come if you're able to reach him. As I indicated to you both separately and off the record, due to the Beyonce concert, I was not able to finish this jury trial that I'm currently, well, we actually just getting started with opening statements. So I have to adjourn your trial, and I didn't bring my calendar downstairs, but, counsel, what's your next available trial date?
If it's a Thursday morning, then
Okay,
we do September 14th
pull that up.
or the 7th.
Ooh.
Richard Gray.
Richard who?
Gray.
Is that MFP?
Yes.
Richard Gray? You don't know? That's the 14th, what about the 7th? Mr. Babish, will you still be with the AG's office in September?
Your Honor, that is not confirmed. It's not really set in stone. However, I'm sure if we set the trial into a date where I'm back at school, I would probably be able to make the trial.
So when do you go back to school?
Next week is my last week at the Detroit office, but I'm hopefully going to be able to continue working out of the Lansing office during the semester.
What about the same?
Voting on that. But no trial.
No trial,
Resentencing.
September 7th.
Review, motion.
So what if I set the trial for September 7th? Would he still be able to do the trial, Mr. Hayes? You don't know?
Judge, I'm not even sure the trial's for surely gonna go. I'm just
Okay. Well, let's set it for September 7th and see. See how that works.
You're looking
Yeah.
at September 7th.
Yes,
I'm scheduled to be in Roscommon that day.
what about September 14th?
I can do the 14th.
All right, let's set it for the 14th.
Great, thank you, Judge.
You're welcome, and thank you, council. Thank you all so much for your accommodation. I appreciate
You
it.
want to have a talk with Beyonce, Judge?
Talk with her and talk to your wife. Tell your wife they can't go to these things during the week. Okay.
You know, I can't control her.
All right, thank you all. Have a great day. Stay safe.
And I did tell Mr. Babish that, if you're gonna get bumped by somebody, Beyonce is a good person to get bumped by.
Yeah, it is. It is.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank
Thank you, Your
Okay.
Honor.
You're welcome.
All right. Okay. Ms. Stevenson.
All right, now back to the business. Yeah. Good morning, everybody. Good to see you all back. Thank you for making it back this morning. Thank you for surviving that storm that we had yesterday in the meantime. So getting right to it, the jury instruction that you're gonna get from the court is that nothing that I say to you is evidence, nothing that Mr. Henderson says to you is evidence. All the evidence that you're gonna get is gonna come from the stand, come from the exhibits that may or may not be admitted. So there's no reason for me to stand up here talking to you for a long time. I just want you to understand and to remember what we talked about this presumption of innocence. I am, however, going to take exception with a couple things that Mr. Henderson said this morning. We believe the evidence is going to show that at the time of this incident, the complaining witness was 60 years old. I'm not in agreement with that characterization of that being an elderly person, okay? So I just want you to think about that. She's 60 at the time of the incident. There's a big age gap between the parties, but I don't know if I'm going to consider that elderly person. And I'm also gonna draw your attention to a description that Mr. Henderson gave of the incident, which was he called it a tussle. And I'm gonna ask you to think about that as you listen to the evidence. We believe the evidence is gonna show you that on the date of this incident, that the complaining witness was at a location where she did not live, that she left the building and tried to get back into the building, and that my client, Ms. Jackson, was closing the door because Ms. Draper was not her guest, that she was, as her right to, closing the door. And as Mr. Henderson just told you, that Ms. Draper stuck her foot in the door and tried to stop Ms. Jackson from closing the door. All the rest of this information, what did or did not happen between Ms. Draper and Ms. Jackson after Ms. Draper tried to get into a building, not by her own host letting her in, but by her putting her foot in the doorway, trying to block Ms. Jackson from closing the door to her own building. Whatever took place after that, we believe the evidence is going to show you that the police came out and that they were not able to determine who the initial aggressor was in this situation, that nobody got arrested. We believe that the evidence that you're going to see in support of Ms. Draper's position that she got beat up is going to be inconsistent with her testimony. And we're going to ask you at the end of the proofs to find Ms. Jackson not guilty, because we do not believe that the people will be able to meet their burden of proof beyond a reasonable doubt that Ms. Jackson committed an assault and battery upon Michael Draper. I do this pretty much every time I come in trial. But everybody remembers those, you don't have to answer because I'm not supposed to ask questions. But I'm gonna trust that everybody remembers those scales of justice that they taught us about in school. And right now, Ms. Jackson is cloaked in a presumption of innocence. And it is the job of Mr. Henderson as the prosecutor to put enough evidence in that scale to tip the scale, not to a place where it's even, I say this all the time, not to a place where it's even, but where the presumption of innocence is removed from Ms. Jackson, and now she's reasonably, without a reasonable doubt, guilty. And we don't believe that the evidence that Mr. Henderson is gonna put in that scale is gonna be heavy enough. And that's because the police are gonna testify to you that when they got out there, they couldn't make a determination. When they first showed up, the Detroit police know what they're doing. When they got out there and did an interview of everybody, they didn't have enough information to say who did what. And told everybody to go on about their business, and they went on about their business, didn't arrest anybody. That is significant. Please pay attention to that testimony, listen to all the evidence, and we'll believe at the end it proves that we're good. We believe you're gonna find this out.
All right, officer, you may pass out the notebooks. Please take one whether you intend to take notes or not. Just, if you don't want to take notes, just put it on the leg. And then the people may call their first witness.
Thank you, Your Honor. The people call Ethel Drakeford to the stand.
Ms. Drakeford, please give your name to the court reporter. And then raise your right hand for me, please. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Counsel, you may proceed.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Could you introduce yourself to the members of the jury?
My name is Ethel Drakeford,
Ms. Drakeford, how old are you?
66 now.
And do you remember where you were on February 17th, 2018?
Yeah,
Where were you at?
at Charles Home, Apartment Complex,
And do you know the address of that?
3236 West Grant Street.
And is that in the city of Detroit, County of
Yes.
Wayne?
Yeah,
And did something happen on that day that brings you to court here today?
yeah.
And why were you at that location?
I was visiting Charles, she was taking from somewhere, I took him to the food bank.
And after you returned, well, let me ask you this, who is Charles Few?
Charles, he was a friend, who was helping me with a probate court case.
Okay, and so when you returned from the food bank, what did you do?
When I returned, he put his box on the front porch. Two of the men that was in the building came out and started chatting, and so forth like that. One of them was her male friend from upstairs. The other one was a person named Lonnie Thomas.
Okay,
Lives across the hall from me.
lived across the hall from Mr. Few.
Yes.
And you said her male friend, when you say her, who are you referring to?
It was a young man from upstairs,
Right, you said it was her friend, so who is the her that you're referring to?
Shavonte Jackson.
Okay, and the person that you're describing as Shavonte Jackson, do you see that person in the courtroom here today?
Yes.
Could you point to where she's at in the courtroom and identify her by an article of clothing?
She's right there, and she has on a black shirt.
Your Honor, if the record, pardon me, I didn't even interrupt you.
Black or dark gray, I can't see.
Your Honor, if the record could reflect that the witnesses identified the defendant in this case, Shavonte Jackson.
I need a little bit more, because there are two ladies sitting at that table with a black dress, a black top.
And white gym shoes, white and black gym shoes.
Okay, would that be the person to your left or right?
To my right.
The record reflects the identification of Shavonte Jackson.
Thank you. So when you said that you returned from the food bank, how were you all traveling?
I was driving,
And when you got to the apartment, what did you do?
after Charles Pugh and the two men were talking and I was talking to them. We went in, he took all his food in, and I was there for a couple more hours.
Where did you park your car?
I parked my car to the front of the house, but there was a lot of water there. So it was kind of like not directly in front of the house, but a little bit to the right side of the house. But it was on the front street, public street.
Had it been raining that day?
It hadn't rained, just like the sewage line backed up and the water was just, but at that time,
Could you describe the building that Mr. Few lived in?
it's a 4 apartment complex.
Okay, and how many are on, or is it multi-level?
Yes,
Okay, how many are on the bottom?
there's 2 apartments on the bottom, 2 on the top,
And what entrance did you use to get into the building?
the front door.
Did that go into a common area or did that go directly into Mr. Few's apartment?
As you open the front door, his door is right to the left side, so just almost walk right into this place. It's only a little small wall between him and that front door.
Okay. And you said that you were there for a few hours. Did you ever hear anyone other than Mr. Few?
Close around about 30-ish, 5, close, it was getting close to 5. I heard Miss Jackson screaming, hollering from upstairs on the 2nd floor. I didn't know why she was screaming and hollering, but she was kind of cursing Charles Pugh out. And you could hear it all the way through the door.
And you said that it was about 4:30 or 5. Would that be AM or PM?
PM.
And you said that she was yelling. What was she yelling?
Just, and she was just cursing Charles Pugh, probably me out too. And so I asked Charles Pugh, why is she doing that? And he said, because you parked in the front of the house where she would normally park.
So once you understood that, or once you perceived that she was upset over a parking space, what did you do?
I told Charles Pugh that I would go and move the car so she could stop cursing him out.
Did you move your car?
Yeah,
Did you see the defendant while you were moving your car?
yeah.
Or what was she doing?
She came out and moved her car.
Okay. And where did she move her car?
She put it in the spot that I moved my car out of.
After you moved your car, did you see the defendant?
When she went in, I saw her and she was walking in.
Okay, did she go in before you?
Yes.
And did you go?
I went in after I parked my car and then I started walking in.
And what happened at that point?
At that point, Charles Pugh was standing at his door. And I don't really see her because I can see clearly Charles Pugh at his door. And
Where-
so
Pardon me, ma'am, where were you at when you saw Charles Street at this door?
walking up the side.
And so what happened after you saw him at his door?
And so when I came on up the steps, I still didn't see her. That's because she was beside a wall by the door. White wall by the door. It's a small wall. Not really about that much.
Would that be on the inside or the outside of
It
it?
would be on the inside.
Okay, if I were standing looking at the door, does the door open in or out?
The door opens, as you, on the inside, you push the door.
So it opens
that way.
in.
Yes,
Does it open in to the left or to the right?
it opens towards the right, because the handle is on the left side.
And so where was Miss Jackson sitting?
To the left side by the wall.
And What happened when you got to the door?
As I got to the door and was about to step in, she grabbed me. And when she did, she grabbed me in my shirt and my chest. And her fingernails were sticking in my chest.
Yeah, did she ever attempt to close the door?
When I first walked up to the door, she went to slam the door on me. And I grabbed it to keep it from hitting me.
Did you do anything else to keep it?
I just put my hands up, trying to, touch it, keep it from hitting me. It was about to hit me.
Okay, and after that, what happened?
Then, as I stated, she grabbed me in my shirt, and her fingernails were sticking in my hand. So when she grabbed me, she pulled me
Pulled you into the,
into the doorway.
okay, and what happened after she pulled you into the door?
She started striking me in my head with a cell phone.
And, you said she started striking your head. Where on your head?
Just facing towards the right, but kind of all over, and then somehow or another, we rolled over some kind of way and went to Charles' door. Because as I stated before, his door is just like, as you walk into that hallway, his door is right there.
At any point, did you cause injuries to Miss Jackson?
No,
Did you?
excuse me, yes, I did. With her fingernail, while we were still in the hallway, her fingernails was in, she had on fake nail. So it was in my skin. And so I just reached down and get her hand, get it out of my skin. It was in my chest.
Okay, other than biting her, did you do anything?
No, I continued to try to block the blow.
Did you ever hit her?
No,
You said that she struck you how many times?
I cannot count how many times. I can only tell you that it was for about a good 15 minutes.
Okay, so did she strike you once or more than once?
Long,
Did she ever stop hitting?
no,
Well, I mean, at some point,
only when her friend came down and lifted her up off me, because I had taken a fall.
okay. And when you fell, what part of your body did you fall?
I fell towards my buttocks and my back.
So did you know you said it ended when her friend came. What did he do?
He lifted her up. He actually picked her up off the floor, like grabbed her, and she was lifted up. And then he just took her, he hauled her upstairs.
After this attack ended, what did you do?
I called 911.
And did you ever speak with any officers? Did you provide a statement to them?
Only to police officer Pulaski.
And did they take any pictures?
No,
Did you take any pictures?
I did.
Okay, and when did you take those?
I took a few pictures of with bleeding in my chest at Charles Park. And then later on, days afterwards, I took a couple pictures. And then I also came back towards the house and took pictures of the outside of the house and where my car was at one time. Point. Even show the water that was sitting in front of the house.
Did you go with EMS on that day?
I went to urgent care that day.
Okay. When did you go with EMS while officers were there?
Ambulance?
Yes, ma'am.
No,
I'm sorry, I'm using the shorthand. That's what I meant. So you said you went to urgent care.
yeah.
And Permission to approach the witness, Your Honor.
You may.
Straightforward, I'm gonna hand you, 4 photographs that have been marked as, people's exhibits 1 through 4. Would you just take a look at those and tell me if you recognize them?
Yes, I do.
And, how do you recognize them?
I'm in the photo and I see the scratch mark, in my chest, the swelling on the side of my face, reddening in the side of my face, reddening, in my skin, near my eyes and eyebrow, and on my eyebrow, and forehead.
And who took those?
I know.
And when did you take those?
These pictures right here was taken at Charles Street Park.
So would that be the day of, or
Yes, that day.
do they, when you look at those pictures, do they accurately reflect what you saw, your face as you saw it on that day?
Yeah.
Have they been changed or altered, or any deletions in any way?
No,
Your Honor, the people would move, states 1 through 4 into evidence.
Any objection?
No objection, thank you.
People's proposed exhibits 1, 2, 3, and 4 are admitted as people's exhibits 1, 2, 3, and 4.
Your Honor, permission to publish the, exhibits to the jury.
May.
Nothing further this time.
Cross examination.
Thank you, Your Honor. Good morning, Ms. Draper.
no,
So. How long had you been at 3236 West Grand, when you first came into contact with Ms. Jackson? At that day?
before I saw her, I had been here around 11:30, take Charles Street to a food.
Okay, so you got to Mr. Hughes' apartment around 11:30?
11:30.
Okay, and about what time was it when you first saw Ms. Jackson?
It was after 4, something like that.
Okay, so before this day, did you know who Ms. Jackson was?
No,
Okay, and about what time was it when you said you heard her upstairs yelling about the parking spot?
it was close to 5 o'clock. I can't give you the exact time, but
Okay,
it was close to 5 o'clock.
okay,
At least that's what it seemed.
okay. So about how long did that yelling go on before you went outside to move your
It
car?
went on for a few minutes.
Okay, all right. Did that make you, did you have any emotional response to that yelling that you were hearing?
No more than asking Charles Street what was going on.
Okay, and so as soon as you kind of heard about what's going on, you went outside?
Yeah.
Okay, all right. And so when you went outside, at some point you try to come back into the apartment, right?
Yes,
Okay. And Ms. Jackson, she had gone out to move her car, is that right?
yeah,
Okay, and so she goes back in before you?
yeah.
Okay, and did you see her inside the building at all, or?
No, and when she was going up the sidewalk, one towards that's the part where I saw her.
Okay, did you follow closely behind her?
No, because I was still trying to move my car.
Okay, so she moved her car and then went back inside?
And I came in last, because I was just parking because opening my door and coming back in.
I understand. Okay, so as you're trying to get into the building, you testified that she closed the door on you, or?
She went to slam it on me.
Okay, and at some point, did you put your foot in the threshold of the door?
Yes, I did.
Okay, when did you do that, Ms. Draper?
As I was fixing to step through the door.
Okay, and is anybody saying anything to you?
Charles Pugh is standing at his door, waiting on me to come in.
Okay, and Ms. Jackson is trying to close the door.
Miss Jackson is trying to slam the door upon me to hit me with.
Okay, what did you do at that point when she tried to hit
I
you?
raised my hand to stop the door from hitting me.
Did you push the door at all?
No, I didn't. I just had to stop it from hitting me.
Okay, so when you testified that Ms. Jackson she's pushing the door closed, right?
She's just slamming the door on me. Just take the door and go, just like that. Just
Okay.
to make it hit a person.
Okay, and then you hold your hands up just to
One
stop the
hand.
door, one
Just
hand up, one hand up to
It's
stop.
straightforward. You have to let the lawyer completely finish their question before you begin your answer.
Okay.
Okay, so you hold up one hand to stop Ms. Jackson from slamming the door on you,
Yeah,
and you have one foot in the threshold of the,
yeah.
okay. And where's Mr. Pugh when this is all going on?
Standing in his doorway. His
Okay.
name is Mr. Pugh.
Mr. Pugh, thank you. Okay, so he's standing in the doorway of his apartment, correct?
Yeah.
And Ms. Jackson is behind the door trying to close the door on you, correct?
I couldn't see Miss Jackson when she first started at me
Mhm.
because she's coming from the side of the wall. There's the door,
Mhm.
there's a little side to the wall
Mhm.
next to the door. That is where she was originally standing. That's why I could see directly at Charles Pugh in the doorway. I couldn't see her, so I'm assuming she had went upstairs.
Okay, but from wherever she is, it's your testimony that she's able to reach over, I guess, around the
Not
door?
really, you don't have to reach over to the door. The door is right there in front. If it's even halfway cracked, all she had to do was grab it and try to shut
Okay, so she's trying to shut the door.
it. Yeah, because she's
Okay.
now appearing. This is when I.
No, ma'am. Other questions? That's okay.
So she's trying to close the door, right?
Right.
And she is able to kind of snatch you up, right?
This is when I'm seeing her.
Okay,
When she comes from the side of the wall.
okay. So is it your testimony that while she's closing the door, she's also grabbing at your shirt?
Not at that time. When she goes to slam the door on me.
Okay,
Because this is when I'm seeing her. She's coming from the side of the wall now.
okay,
Now I can see her.
okay.
When she goes to try to slam the door to hit me with it. And again, my foot is on the threshold, so I'm about to enter into this doorway.
Okay.
So then, when I stopped it, that is when she grabbed me in my shirt, and her
Okay.
fingernails is sticking in mine.
Okay, so she, at the same time then, she's closing the door on
Not
you.
at the same time.
Okay, how much time passes?
Well, I don't, what was the question?
Well, I'm trying to get a time frame here. I'm trying to find out exactly when, really, how Ms. Jackson is able to close the door and grab Ms. Draper.
It's only within a few seconds.
Okay,
Slamming the door didn't work, so she grabbed me in my shirt.
okay, so you kind of have your hand on the door,
Yes.
stopping it, and
Yes.
then she grabs you?
Yes.
Okay, all right. And what's Mr. Few doing when that's all going on?
Standing in the doorway,
How long have you known Mr. Few at the time of this incident?
probably 20-some years.
Okay, and he sees this happening to you?
Yes.
Does he intervene at all?
No.
Okay, all right. So then Ms. Jackson, she has your blouse or your shirt. She grabs your shirt, correct?
Yeah.
And she pulls you into the building, correct?
Yeah.
Okay, What does Mr. Few do when Ms. Jackson grabs you by the shirt, drags you into the building?
He's watching.
Okay, all right. And so when did you ever hit Ms. Jackson at all?
No,
Okay. So you did indicate that you were able to bite Ms. Jackson's hand to get her off of your shirt, right?
yeah, you
Okay.
get her fingernail out of my chest.
Okay, all right, so can you please, I'm trying to understand how that happened. So she grabs your shirt, right?
Yeah.
And are you standing up? Have you fallen down or
At that time, I'm standing up.
what do you do when she has you by the shirt and then what do you do?
I just reached down and get her, to get her fingernail out of my chest.
Okay, you didn't try to push her off of you or
I tried
anything?
to block the blows that was hitting me as she was hitting me with her cell phone.
Okay, all right, I'm gonna get back to that. How many times do you think you were struck by Miss Jackson?
I cannot tell you that because I can only assume that it's like 15 minutes, something like that. I can't, when somebody's striking you in your head,
Yes,
you're not trying to count
I get
how
that.
many times they're gonna hit you, how many times they kill you.
Okay, but did she hit you more than 5 times?
Yeah,
Did she hit you more than 10 times?
yeah,
Did she hit you more than 20 times?
yes,
Did she hit you more than 30 times?
yes, she never stopped hitting me until the young man lifted her up off me on the floor, because I took a fall.
Okay, did she hit you more than 40 times?
Yes,
Did she hit you more than 50 times?
I cannot tell you that, ma'am, I can only tell you it was about a good 15 minutes, she never stopped.
Okay, all right, so at some point, so she hit you at least 40 times. At what point are you standing up while this is all happening?
No.
Okay,
At some point, I fall down over a bike,
okay,
in a box,
okay,
and it jabs me in my leg, my right thigh, and my left shoulder, the bike in the box.
okay. During those 15 minutes, Ms. Jacob, during those 40 times that Ms. Jackson is striking you, does Mr. Few ever try to help you?
No, because he's afraid to.
Oh, okay, all right. And so, did Ms. Jackson strike you with an open hand or a closed hand?
Miss Jackson struck me with her hand around herself,
So these 40 times that she's hitting you,
40 or more.
40 or more times that she's hitting you with a cell phone for about 15 minutes. That's what happened?
Yeah.
Okay, all right. And so, when, after this is all done, you said you called the police?
Yes,
Okay. And did you have an opportunity to talk to the police that day?
yes,
Okay. Did you tell the police what happened to you?
yes.
Okay. Did they call EMS for you?
He asked me, did I want to see EMS?
Okay. Did you tell him whether you wanted to see EMS?
No, I told him no.
Okay. All right. And, so you indicated that after you left, the Grand Street address, you did go try to get some medical attention.
Yes, I did.
And where did you go for the medical attention?
Women's urgent care was one facility.
Okay. So all right, so when did you go to the Woodland Urgent Care?
That night,
Okay,
I went straight there.
okay, and did they give you saw a physician there?
Yes,
And they didn't give you any discharge instructions or anything like that?
yes.
Okay, what kind of treatment did you get?
They just examined me and they gave me some diagnosis and gave me some, and they observed my condition that I was in.
Okay, do you know what kind of diagnosis they gave you?
Yes, I do.
I'm not sure that Judge Draper has some paper.
This is Woodland Urgent Care. Discharge.
Whatever papers you have in your hand, in your lap, remove them. Tell them to remove the papers. Okay.
Okay, so did you get discharge instructions from the Woodland Urgent Care?
Yes,
Okay, and then, I'm sorry, what kind of treatment did they give you?
they just observed me that night. And since I already had prior injuries in my body, they did not have to give me any medication. Most places will not give me any kind of medication because for 20 years I have had injuries in my body from my neck down to my feet in every joint in my body.
Sorry about that. So did you tell them what happened to you? Why
Yes, I
you
did.
Okay, all right. Your Honor, may I approach the witness, please?
You may.
So, Ms. Drakeford, I'm gonna ask you just to take a look at this document I'm handing you. Kind of just read it over to yourself, and once you finish reading it, could you look up so that I know you've read it now?
All right.
You read the whole thing?
All right.
Just read and then look up.
Okay. Approach the witness.
You may.
Thank you, ma'am. Okay, so do you recall going to the Woodland Urgent Care and being advised, well, being prescribed some ointment?
Yes,
Okay. And do you recall them telling you you had a superficial injury?
the superficial,
No, ma'am. Listen to the question. Do you recall them telling you that you have a superficial injury?
yeah,
Ms. Stevenson?
Do you recall them giving you any kind of treatment for being hit in the head 40 times, 15 times?
they informed me to go to ER. If
Okay,
there were any other problems with it. They.
I apologize. The question is, do you recall them, prescribing or giving you any treatment for, what did you say? Being hit in the head? Did you
40
get-
to 50 times for
They
15.
would,
Did you receive any
they
treatment?
would not give me any type of medicine.
Do you understand the question?
It's not quite
Right,
like
okay.
saying treatment.
Did you receive any medical treatment when you went to the urgent care for being hit in the head? Is what her question is. That is a yes or no question, do you?
No,
Okay,
other than their
No.
observation.
okay, Ms. Stevenson.
Okay, all right. So, I do wanna ask you a couple of questions about that building in West Grand. Okay, so when you first when you first got to the building that day, you went inside with Mr. Pugh, correct? With Mr. Pugh, right?
Yeah.
Okay, and does he use a key to get into his building?
If the door was open, I think the door was already open because the two men
Okay,
came out.
is there a buzzer on the door?
And yes, there's door there.
Okay, so sometimes, you know Mr. Pugh for like 20 years at the time of this incident?
Yeah.
Okay, and sometimes you go over and visit him, is he already at home?
Yeah,
Okay, if you ever have to push a buzzer or doorbell or anything like that?
yeah.
Okay, all right. All right. Okay, I don't have anything further.
Redirect.
Yes, Your Honor. Just straightforward, you mentioned Mr. Few. How old was Mr. Few at the time of this?
Uh, 3 or 4 years old.
Okay. And is Mr. Few living now?
No, he died
And do you know when that was?
last year.
We talked a lot about your treatment on cross-examination. Have you received any other treatment for the injuries that you suffered on, February 17th, 2018?
Yeah,
And what is that?
on February the 19th, I went into Providence Hospital ER because on the 18th, I didn't have floaters in my right eye. And then they took a CAT scan, said it was normal, but I had floaters in my eye where I couldn't see. They described either they or was it urgent, I don't think, because she doesn't have all the medical.
Ma'am, please just answer the question.
Someone described that I had contusions on the forehead and on the side of my face. Also reddening on the side of my face and to my forehead, round about the eyes.
Okay,
And then after that, by the time the February 23rd came along, I went into my pain and rehabilitation doctor's office. He stated that I had abuse on my right thigh and on my left arm. He stated that he noted in his medical report that I was complaining that I had been attacked, taken a fall, injured my back. We would later find out through other
Counsel,
tests.
this is a narrative.
yes, Your Honor. Did you receive any further treatment for your back or your hip area?
Yes.
What was that?
I would do steroid shots. I would do physical therapy. I would do nerve blocks into my back, lower back, where they would stick the needle into the lower part of my back and inject it with medicine.
Okay, was there any other treatment you
Yes,
received?
I would have surgery because of the fact that I ruptured my pelvis and I injured my sacroiliac joint. So I went
And you ruptured that, injured that, how?
when I took the fall in Charles Street House.
You mentioned a bike and a box. Is that all you're referring to?
Yes, I fell over a bike in a box into the floor.
And I believe you said something about the day of when you were discharged, something about them saying that to go to the ER? If, what were you advised on?
They were advising me that after they observed me, is that if I had any, they diagnosed me with having dizziness and.
Ma'am, please focus on the question being asked. Restate your question.
Yeah, what did, you started to say on cross-examination, what did they say about the ER on that night when you were discharged?
That I was simply in an urgent care facility, and that if I had any other problems, to go to the ER.
Nothing further, just.
Okay, so did you go to the ER?
Yes, I did.
Okay. So. Do you have anything that shows what they did at the ER?
It's in my pack.
Okay. I don't have a paper.
Ms. Drayford, I have a couple of questions for you, ma'am. My first question, Ms. Stevenson asked you about the doorbell and whatnot. You remember those questions by Ms. Stevenson?
Yes.
And then when you testified about what happened, you said you were going in the door and that Ms. Jackson pushed the door to close it on you, but you stopped her.
Yes.
Okay. My question is, why did you do that? Why didn't you just, why didn't you let her close the door and you push the doorbell?
Because the door was about to slam onto me. My foot was on the threshold. So as I saw the door fixing to hit me, I just stopped the door from hitting me.
Okay. And then after she pushed the door on you, your testimony is that then she pulled you into the door, inside the place. Okay. My other question just is, you described to the jury some extensive, injuries.
Yes.
When the police came, you said they offered you to go to, or they offered to call EMS, but you declined. Do you remember that testimony?
Yes, I did.
My question is, why did you decline?
At the time, my head was not hurt.
What about your pelvis?
I was so shaken up behind this incident.
No, I asked you, what about your pelvis?
When I went to, let me just say it like this. It is stayed in my.
No, I didn't ask you what was stated. Please focus on my question.
Okay.
I'm asking you, ma'am, please just focus, okay? Go ahead, focus, okay? My question to you is, after this incident, you said your head wasn't hurt yet, and then I'm asking you, what about your pelvis? How did your pelvis feel? Because you said you ended up having to have surgery on your pelvis. Is that what you said?
Yes, I did.
Right, so I'm asking you, after this incident, how did your pelvis feel?
When I gotta go, I am stiff. I have injuries in my body, from my neck down to
I
my.
apologize, ma'am.
But
I apologize. I apologize to you.
So
I apologize to you. My question is not about from your head to your feet. I'm really, literally, I'm asking you, how did your pelvis feel when you finished? Did you feel anything wrong with your pelvis?
Actually, I was too nervous to feel it.
Okay, and then you did say that you, after this, and you declined the EMS from the officers. Then I believe your testimony is that you then drove yourself to the urgent care. Is that your testimony?
Yes.
My question to you is, how did your pelvis feel when you got in the car and you was driving yourself to the urgent care?
I'm aching in my body. And it's
And you
staying
were aching in your pelvis?
And, it's in my medical.
I'm not asking you about those medical
I'm
records,
80.
Ms. Drake Ford. I'm asking you about your recollection of how you felt after you finished the incident. So I'm just asking
I
you,
am.
please don't overtalk me, Ms. Drake Ford. I'm asking you, how did you feel when you were driving to the, urgent care? That's what I'm asking. Since
Just an 80.
okay, and then I think my final question is, when you got to the urgent care, so not the ER, when you got to the urgent care, did you advise the urgent care that you had been hit in the head over 40 times?
I just said I had been hit.
My question, so that's a no. You didn't tell them how many times you had been hit in the head?
No,
Did you tell them the length of time that you had been hit in the head?
I'm not sure.
Okay, when you went to the urgent care, not the ER, when you went to the urgent care, did you tell the urgent care that you had fallen on your pelvis?
I'm not sure. I have to look into my medical papers.
I'm asking you about your memory though. Do you recall if you told them?
I'm not sure.
Okay, all right, thank you so much. Are there any questions based on my questions on behalf of you?
Yes, sir.
Thank you.
At what point did you realize the seriousness of the injury to your pelvis?
My pelvis, by the time, by the time I got to on the 23rd, I am aching from my lower back into my buttocks into my thigh. I do not know what is happening to me at that time. And through other types of testing and examinations, they would eventually find out that, and through,
non-responsive.
Sustained.
Okay,
they would eventually.
Well, no, ma'am, no, ma'am.
I'll ask you a question, Mr. Ricker. So, through further testing, what did they eventually find?
Eventually, Dr. Ferguson would run a dye down into my back to see if it was going to leak out into the lower part of my back. And he was looking for where would it
Now, someone, she doesn't know what he was looking for. I really need her to be responsive.
Yes, sir.
when he got
What was the result?
the result was I had a ruptured pelvis and a sacroiliac joint injury.
You said sacroiliac
Joint injury.
Thank you, Mr.
Any, Ms. Lee?
And do you have records of that here today?
And Mr. Henderson has that information.
Okay, and then let me ask you something. So up until this time, up until this point right here, do you consider yourself to be in good health at the time of this incident?
No,
Okay, we're kind of poor health at the time of this
I
incident?
was listed already in chronic condition.
I'm sorry?
I was listed as chronic condition.
Okay, like what kind of chronic condition?
You want me to call it all off?
Like 5?
Cervical disc injury in my neck, both
So a
rotator cuff
cervical
injury in my neck.
you already have some kind of neck thing.
Both of my rotator cuffs are torn, right
Shoulder
shoulder
problem.
torn. Yeah. I have a lumbar strain, a protruded disc, and a pinched nerve,
Okay,
and now a sacroiliac joint problem and hip problem in my body.
okay, all right, thank you.
Anything from you?
Okay.
I thought Ms. Stevenson was gonna take a little longer.
Sorry.
Now I need some water. Okay. I couldn't sleep. All right. Thank you, Ms. Drakeford. You may step down, and if you would like to, you are free to remain in the courtroom.
May I speak?
No, you may not speak freely, ma'am. This is court. We don't speak freely.
All right.
We only speak in response to questions. No, ma'am. Don't talk. Don't talk. Mr. Keith, I was calling you from the lawyer this morning. I'm sorry, Counsel. Mr. Henderson. Any other witness on behalf of the people?
None on behalf of the people, Your Honor. At this time, the people rest.
Okay. Ms. Dixon, are there any matters to be taken outside of the presence of the jury?
No, thank you.
Okay. Mr. Henderson, you may proceed. Ms. Dickinson, anything at this time on behalf of the defense?
Yes, Your Honor, but could I? Break.
Yes. Okay. We're gonna take a short break. If you have taken notes, leave your notes in the chair and we'll be back in about 5 minutes.
All right, to the jury.
The jury room is locked, ladies and gentlemen. You don't have to bring all your things into the courtroom. Only myself and Officer Krabs have the keys to the jury room. All right, you may be seated, and we're on a 5-minute recess.
Thank you. Your Honor, right now I'm calling officers.
Okay,
Oh, okay.
so, but, well, and then you still haven't made up your mind?
Not yet.
Oh, okay, that's fine then.
Okay.
So I'm ready for the jury then.
She,
All right. Well, we're supposed to do some happening right now. So. She wants me to read that. Okay, you may be seated. What's your? So she was. And we're back. I don't know, she was in here. Okay, all right, Ms. Dixon, the people rested. Anything on behalf of the defense at this time?
Yes, Your Honor. On behalf of Ms. Jackson, we would call Officer Edward Powlouse.
All right. Your name's on the report. Thank you. And then step towards me, raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for me.
Police Officer Edward Pulaski.
Officer Pulaski, did you watch these proceedings on the live stream?
No.
Thank you, you may be seated. Dixon, you may, yeah, and also, you're aware, yeah, Mike.
Does that sound good?
Yes, sounds great.
Okay.
Good morning, Mr. Powlouse. Can you tell the jury your name, please, sir?
Police Officer Edward Pulaski.
Okay, and, where you are employed right now, correct?
Correct.
By whom?
Detroit Police Department.
Okay, and what's your rank with the Detroit Police Department?
Police officer.
Okay, and were you employed with the City of Detroit Police Department on February 17th, 2018?
Yes,
Okay, and how were you employed with DPD at that time?
as a police officer.
Okay, And did you have occasion to respond to a run to 3236 West Grand Street in the city of Troy on February 17, 2018?
Yes,
Okay, do you recall that run?
I do not recall that. I need to remind myself of my report.
Okay, so do you know if you made a report of that run?
I did.
Okay, and would referring to your report from that run refresh your recollection as to that run?
Yes,
Okay, all right. So. Judge, I do now possible, so if I go one way. Okay, all right, so could you got your report with you?
I did not, but I reviewed it before I came in.
Oh, great, okay. So do you recall, after reviewing that report, can you tell us about that run, officer?
Yes, we were called there for, me and my partner were called there for an assault and battery police run. When we got there, I spoke to both the victim in this case and the defendant in this case.
Okay,
They stated there was an argument over a parking spot. I believe it was the words of the victim. She said there was a tussle.
okay,
And after that, after speaking with them, I observed a bite mark on Miss Jackson, and then.
okay, so let me just stop you for a
Okay.
minute. You did have an opportunity to talk with both parties.
Yes,
Okay, so one of the parties you talked to was Ms. Jackson,
correct.
and you see Ms. Jackson in court today?
Yes,
And she is the complainant or defendant?
defendant.
Okay, and then you also talked to another individual?
Yes,
That was,
Miss Drakeford.
okay, you
Yes.
see Ms. Draper in court today?
Yes,
Okay, and so, you said that you observed injuries?
yes.
Can you describe the injuries that you observed? You observed injuries to one party, both parties?
Both parties.
Okay, can you describe the injuries you saw to Ms. Draper?
There was a little bit of redness on her temple, and she had a scratch on her chest.
Okay, and can you describe the injuries you saw to Ms. Jackson?
There was a bite mark on one of her fingers. I don't exactly recall which finger it was, though.
Did you have an opportunity, I think I asked you this already, you had an opportunity to interview Ms. Jackson?
Yes, I spoke to both.
Okay, and so you had an opportunity to talk to Ms. Draper? Okay, did you make an arrest at that time?
Did not.
Okay, so as of February 17, 2018, how long had you been an officer with Troy Police Department?
It would have been around 2 years.
Okay, and had you had the opportunity to make arrests for self-defense in the past?
Yes.
Okay, why didn't you arrest anybody here?
Both were making claims that the other was the aggressor. We couldn't determine at that time who was the actual aggressor in the fight. So I let that be decided by the detectives once they completed a more thorough investigation.
Gotcha, okay. And did you call EMS?
Yes,
Did EMS come out?
they did.
I'm sorry,
They did. Yes,
EMS came out?
yes.
Okay. And do you recall EMS recall EMS treating anybody?
I believe my report said medic 18 minutes seen and looked at Miss Jackson, but she did not want to go to the hospital.
Okay. All right. Okay. All right, thank you, Officer Pulaski. I don't have anything further.
Cross-examination.
Yes, Your Honor.
Good morning.
When you arrived on scene, Ms. Jackson told you she was angry over a parking spot.
Object to a mischaracterization of the testimony.
It's cross-examination, I'll allow it.
Thank you.
Counsel.
Like I said, I don't recall the events. I'm going based off my report. Both of them stated there was an argument over a parking spot.
So Ms. Jackson did tell you that there was an argument over a parking spot,
Yes,
but she told you she was angry over a parking spot, right?
I'd have to refer to my report to see if she said she was angry about it.
Your Honor, may I approach the witness and, well, what you said, reviewing your report would help recollect.
If I said how she was acting, yes.
You may. You may.
I'm gonna hand you some papers. I want you to take a look at it and tell me if you recognize it.
Yes,
And is that your report?
yes,
Okay, is that an accurate representation of your report?
yes.
Okay, could you, yes, could you refer to this page? Could you review it and then look up at me when you have? Is your recollection refreshed?
Yes,
Okay. Miss Jackson stated she was angry over a parking spot, right?
yes,
And in your report, you listed the victim V1 as Ethel Draper.
yes,
You didn't list Miss Jackson as V2, V3, anything like that.
no,
Did you talk to Mr. Few?
no,
Once you're done with a run, if any further investigation needs to be done, it goes to the detective, right?
correct,
Okay, so you didn't obtain any medical records,
no,
and it's been 5.5 years.
correct,
You don't remember that much about it.
no.
You do remember that there was no bruising in Miss Jackson's face.
I did not put it in the report, no.
So if you had noticed any, you would have put it in.
Correct.
Okay. And how many runs have you made since then?
I could tell you probably, I mean, we were back then probably 20 to 25 a day during the summer,
So you've made over 500 runs since then.
easily.
Okay. Over 1,000.
Probably, yes.
And how many calls that you go out on do you not make an arrest?
Most runs we don't make arrests on.
Nothing further this time.
Any redirect?
Yes, so if you make a run and one of the parties tells you they've been hit 40 times in the head, is that kind of case you might make a run and make an arrest on?
Yes, this one makes that statement, there's evidence pointing to the fact that they were injured at that point, yes.
Okay, so if they tell you that, and then there's some corroborating evidence, somebody's going to jail.
Correct.
And this night, nobody went to jail.
Nobody went to jail that day.
Okay, see,
Nothing further.
Officer, I have a question for you. You said you did not, question Mr. Pugh?
I did not.
Why not?
He did not make himself available on the scene to me that day. It's not somebody, if I would have spoken to him, if he would have made himself available to speak to me, I would have put what he said in the report.
Did anybody tell you that Mr. Pugh stood right here and saw the whole thing?
Nobody ever seen it, no. Because they would have also been in my report. Yeah, seeing his name later on, when the investigator got it, that was the first time I saw his name or heard his name.
When you say he didn't make himself available to you that night, that means when you went on the scene, you saw Miss Drakeford and you saw Miss Jackson, but you did not see a man that was identified as you or somebody.
Yes, no one by that name came forward stating they saw what happened.
And then you say you were surprised when you saw him in the investigator.
I wouldn't say surprised, it was just the first time I seen that name.
Okay, thank you. All right, any questions based on mine? Ms. Stevenson is your witness. Any questions?
so when you get there, do you remember who you saw when you arrived at the scene?
I don't remember who I saw when I first got there. I'm assuming I saw this Drakeford first. That's the first person I listed that I spoke to.
Okay.
Right.
Do you remember where the parties that you talked to, do you remember where they were when you got
I do not.
there? Okay, all right, thank you. I don't have any.
Mr. Henderson?
Okay.
Thank you, officer. You may step down and is the officer free to leave?
Yes.
Yes, ma'am.
And
Thank you, Your Honor.
free to leave. You're welcome. Anything further on behalf of, the defense at this time?
At this time, you're under defense arrest.
All right, can you, Let the jury step out in the hall for me, please.
All right, so jury. All right.
Oh, thank you. Hold on. I mean, they can stand up here. Okay, they can go now. Just in the hall right there. No, leave your pen, leave your books. And just kind of away from the door, but they, just right there. Ms. Jackson, state your name. All right. Ms. Jackson, your lawyer has indicated that she rests, meaning no more evidence on behalf of the defense. You understood what that meant?
Yes.
Do you understand that while you have a right to remain silent, you also have a right to testify?
Yes.
And do you understand that the decision to testify is yours alone?
Yes.
And have you talked to your lawyer about whether or not you will or will not testify?
Yes.
And is it your decision not to testify? Has anyone threatened you in any way or promised you anything to get you to give up your right to testify in this case? All right, thank you. Okay, you can bring the jury back in.
All right, so the jury.
Oh, it was some more in the hall?
Yeah.
Okay, well, Officer Graston, I don't know if you want to, or did you want to just do it personally?
I could just,
Say that again?
I just want to thank them.
Okay, go ahead. Go ahead. You may be seated. All right, defense has rested any rebuttal on behalf of the people.
No, Your Honor.
All right, are the people ready to proceed to closing argument?
Yes, Your Honor.
Is defense ready to proceed to closing argument?
Yes, thank you.
The people may proceed.
Thank you, Your Honor. An elderly lady getting pummeled. That's what this case is about. It's about a beatdown. The little old lady, somebody cussing at her, yelling at the person whose apartment she was in about a parking spot. What did Miss Draper do? Did she show her, I'm a real one? I'm gonna put her in her place. No. She was a peacemaker. She's yelling about the car, I'm gonna move the car. I don't want the smoke, don't want a problem, just want it to stop. That's it. She moved her car. Defendant put her car where Miss Draper was. In her mind, it was over. She complied. Now look, she didn't have to. She could have left her, it's not a marked parking spot. She could have left her car where it was. She's like, hey, I don't want any trouble. That's it, I'm moving my car. When she tries to go back in the building, the door is about to get slammed on her, and she sticks her hands up to prevent the door getting slammed in her face. That's it. It's not an aggressive act. And then she gets pulled in the building, nails dug in her chest, she's getting hit, and she says she bit her finger, she did not strike her, she was trying to push her away. That's one witness. But what did the other witness in this case say? I looked in Ms. Jackson's face, there was no red marks. That's consistent. That's corroboration between the testimony right there. She didn't punch her in the face. She was getting beat down. This wasn't, you could describe this as a tussle, and I misspoke in my opening statement. I apologize, but really this was a beat down. It's not a tussle. It's a little old lady getting beat down by someone who's faster, who's stronger, who's younger. How long did it last? Did it last for 15 minutes? It felt like 15 minutes. Ms. Draper told you, she said, and I remember, there's some things that caught my ear during this trial, and I hope that they caught yours. She said, I wasn't counting. Mike Tyson said everybody has a plan until they get punched in the face, and that's exactly what happened. Ms. Draper got punched in the face, and she was in shock. She had a very serious hip injury that she didn't even realize until a couple days. She was in shock. She got punched in the face, and that was it. She was just trying to make it stop. Did she get hit 40 times? It felt like 40. It felt like 40. But the judge is going to tell you, you can believe some of what someone says. Part of it, all of it, none of it. That's up to you. None of us get to make that determination. You determine what you will believe from what you heard here today. And so if you were to say, I don't think it was 40 times, I don't think it was 15 minutes. But it was a hit. There was an offensive contact between her body, Ms. Jackson's body, and Ms. Ethel Drakeford's face. Okay, if you make that determination, that's assault battery. Now, Ms. Drakeford told you she fell over this pipe, she fell over this box, and she told you, I was listening, because what I say, it's not evidence. I want you to remember what is evidence, what was said from the stand. Mr. Few was scared. He's a 63-year-old man, he's scared of this girl. He did not intervene. Now, may he rest in peace, he's not with us today, so we can't have him here to testify. But the officers didn't follow up and get his testimony. The officers, I respect the Detroit Police Department. They go out on a lot of runs, but it sounds like this was just another day in Detroit. They went out, something happened, or whatever. They did it. Officer Pulowski did mark Ms. Drakeford as victim 1, which tells you something. But for him, it's another run. He's had thousands of runs since then. It was another day in Detroit. But it wasn't another day in Detroit for Ms. Drakeford. This is a day she's never going to forget for the rest of her life. Because it affected her. She will always remember this day. It wasn't just another day. Something bad happened, and it was at the hands of Ms. Jackson. You heard Ms. Drakeford testify. And under repeated questioning from myself, from the judge, from the defense counsel, everybody questioned her. And while it's been 5 years ago, she did remember that day. She did remember the layout of the building, parking spot, the specifics. We beat that horse to death. Was she pushing the door? Was she resisting? Was she making some kind of, why couldn't she just have, she said, I just put my hands up. She remembers getting struck about the face. She remembers the nails digging into her chest. She remembers fighting in desperation. Her testimony was credible under intense questioning. You saw sometimes she had to stop to be able to understand the questions because we're just tossing them all at her, but she was consistent that this happened. If she had testified that it took precisely 5 minutes and 35 seconds and she was struck 17 times, you'd be like, she's right. Nobody knows with that kind of specificity, but she knows she got rocked. She got beat down. She remembers that, and she's never going to forget it. Here's the thing. I don't have to prove to you. Everybody talks about my burden of proof. I don't have to prove to you that it was 30, 40, 50 times. I don't have to prove to you that it was 15 minutes. What I have to prove, my burden of proof, which I embrace, I don't run from it, is that there was one instance of offensive touching, violent touching, harmful touching that was not welcome by Ms. Drakeford and that was intentional by Ms. Jackson. The fact that she struck her repeatedly proves that it was intentional. It wasn't an accident. It was intentional. She did what she came to do. That's a conviction. That's a conviction. It doesn't have to be 40 times. It doesn't be raining down blows to get a conviction. It's charged with one count, one instance of touching on that day in Detroit and we approved that. We have met our verdict, members of the jury, and after Ms. Stevenson, pardon me, has a chance to speak to you, I'll come again and ask you to render the only just and fair verdict in this case, and that is a verdict guilty.
And I thought, I thank you for taking any notes. I think you were. I wanted to, make sure you don't take that these are closing arguments. Your point? Oh, yeah, it's still.
Just needs- Okay, so I'm glad that you guys have the pictures. Because I want you to look at them, right? And I want you to take a look at the pictures. And I want you to recall the testimony of Officer Pulaski. And I want you to recall the testimony of Ms. Draper, specifically with regard to what she said about her medical report, when she went right to the doctor the next day. Because I believe that all of that makes her testimony about what happened to her incredible. It's not. Now, fortunately, as a jury, you're not charged with, telling Ms. Draper, you're a liar, Ms. Draper, you're not telling the truth. You don't have to do that. That's not your job. Your job is to determine whether or not the evidence that has been put forth weighs enough, is heavy enough to remove that cloak, that presumption of innocence away from Ms. Jackson. Is it enough? Now, I don't know if 63 years old is so old where you see your friend of 20 years getting beat up, you just kind of stand there and watch it happen. That doesn't make any sense to me. I don't know if you, 63, you're not old enough and scared enough at 63 years old, watch your friend, somebody you've been friends with for 2 decades get beat down and you just kind of stand there and don't do anything. That's what Ms. Draper told you was happening. That Mr. Hugh, God rest his soul, he didn't jump in, he didn't call the police, he just was there. That doesn't make any sense. And that decreases her credibility. The officers they said, Officer Pulaski said he went out there and he had a conversation with both parties. The only person he saw when he got there, people that he saw when he got there is Ms. Jackson and Ms. Draper. He didn't see Mr. Hugh or nobody else. Nobody else comes out there and says, do you know what just happened to my friend of 20 years? That girl upstairs, Kate, was wailing on her with a cell phone. That's what I saw, and I want you to take her to jail because she hurt my friend. There's nothing like that is happening. Nothing like that happened. And it's reasonable to conclude that nothing like that happens because things that happen to Draper said. It's reasonable to conclude Ms. Jackson, who went up into the house before Ms. Draper. She goes up into the house before Ms. Draper, and then she kind of just stands there, eyes away from Ms. Draper, and Mr. Hugh stands there. These are hopes. And then when Ms. Draper is just about to slam the door on her, then Ms. Jackson, while she's slamming, reaches over, snatches Ms. Draper up and pulls her in. And then when the EMS shows up, after the police call the EMS, it's not Ms. Draper who is in, by her own testimony, poor health at the time of this incident, because of all these other ailments that she has, all this stuff is going on with her. EMS shows up, she just got beat up for 15 minutes. 15 minutes. 15 minutes, she got beat up, hit more than 40 times. She's already not healthy. EMS shows up. She's not the one who has EMS checking out. It's my client. It's Ms. Jackson who has EMS look at what happened to me. And when the police show up, Ms. Jackson, who supposedly beats up this old lady, and that's not old, okay? You're not old right there. Then Ms. Jackson talks to the police talk to Ms. Jackson, the police leave without arresting anybody. Now, Officer Kowalski told you, if somebody, I don't care how many times I go out, if somebody tells me that they got hit upside the head with an object 40 times, and I see some evidence to corroborate that, somebody's going to jail. Nobody went to jail. Both parties talked to the police. Nobody's running away from the police. Only the defendant seeks the attention of the medical professionals who show up. Ms. Draper goes to the doctor the next day and they give her some ointment. She tells them, I got attacked. And they're like, here's the ointment. Now, again, you don't have to go in there and say, well, you know, it's not like, okay, I didn't, nothing else makes sense, so I gotta believe Ms. Draper. You don't have to do that. You don't have to figure out who's lying. You don't have, that's not what you're doing. You don't have to go in there and call Ms. Draper. All you have to do is determine that evidence, and all the evidence in support of whether things happen the way Ms. Draper says they happen. All that evidence comes from Ms. Draper's testimony. Is it heavy enough? Does it weigh? Which way is it go? Is it heavy enough? Put that evidence in the scale. Does it make the scale like go like this? And like, okay, yes. Is it heavy? No, it's not. It's not. It doesn't make any sense. It doesn't make any sense if this Mr. Pugh is gonna let his guests get beat up right there. Nothing. Nothing. It doesn't make any sense that Mr. Pugh's gonna let his guests get beat up, and when the police come out, not come outside and say nothing. That does not make sense. It does not make sense that Ms. Draper, who's already not helping, when the EMS comes out, no, I don't need it. Urgent care. I'm not going to see my own down. Urgent care tomorrow. That makes sense. Okay? Does it make sense that Ms. Jackson and Mr. Pugh are inside the apartment, and Ms. Draper comes up, Ms. Jackson behind the door, she's gonna slam the door on Ms. Draper, and Mr. Pugh's just gonna stand there, and then Ms. Jackson will reach around the corner and snatch Ms. Draper inside the building, and then when the EMS shows up, it's gonna be Ms. Jackson who says, look at my. It's not enough. You don't have to come out here and say, okay. Disrespect. But the evidence of the people that put in the scale is not heavy. Doesn't. And I'm asking for Ms. Jackson.
Yes, sir. Let's talk about what makes sense. I love it that we get a jury of our peers because you live in Detroit. You know what makes sense. It makes sense that when that when you live in the building with someone and you're gonna have to continue to live in the building with someone, and you're 63 years old, you don't wanna move, you don't wanna call the movers, 2 men in a truck or whoever, you don't wanna have to look for another apartment that you're not talking to the police, because you don't know when they're moving. You don't want a thing where you're forcing them out or they're forcing you out. It makes sense. Honestly, it makes sense because people in Detroit don't always talk to the cops, don't always say, I want to be a good citizen. Let me just tell on everybody on my block what they're doing. When the cops come out, the doors go shut and the blinds go closed. You're a jury of her peers, both their peers, and you know that. So Mr. Pugh didn't want to go out and make a report and live in hell every day from his upstairs neighbor. We know that the man that was there was strong enough to pull Ms. Jackson off of him. So there may have been several considerations that were going through Mr. Pugh's mind, to be honest, and that does make sense. What makes sense is that we would have called him if he wasn't dead to explain his actions. And I'm sorry that he's passed away. May he rest in peace. And I hope that he is in peace. Now we're still litigating this, but that makes sense. That makes sense. What makes sense is that Ms. Drakeford was shook. She didn't know what was happening. She wasn't sitting down going, okay, do I need to get in this now? When should let me make a plan of when I will do all my doctor's visits. She's like, completely, it took her days to even realize what was going on with her back because she was so shaken up from this event. And so, yes, she didn't go with EMS at the moment, but there were injuries and she testified to those injuries. It's not serious and it's not simple. That's what the defense would have you believe. But it is serious. It is serious. An old lady got beat up over a parking spot because she was angry. It is serious. She had serious, she's talking about her back. You saw the bruising. It is serious. This is serious. She's gonna beat up old people in Detroit. No, this is serious. And it is simple. And it's simple because of what you're gonna hear the judge say. A battery, we have to prove, our burden is to prove that Ms. Jackson committed a battery on Ethel Drake. A battery is a forceful, violent, or offensive touching. One, forceful, violent, or offensive touching on Ms. Drakeford that was intended by the defendant and was against Ethel Drakeford's will. I want you to listen real carefully when the judge reads instructions, because I want you to listen to her say that it does not matter whether the touching caused injury. That's not my burden. My burden is a battery on Ethel Drakeford. That's a forceful, violent, one, forceful, violent, or offensive touching intended by the defendant against her will. That is our burden. And now you may say, well, what is proof beyond a reasonable doubt? You know, we got the scales and we're talking about proof beyond a reasonable doubt. This is very seemingly heavy by the way that the defense described the burden that we have to carry. And I asked you two questions. I asked all of you two questions in jury selection. It wasn't biased. I said, do you know anything about the case? You said no. And I asked you, are you completely impartial? Right? And all of you said you were. So if now you all go back there, you know, like, yeah, we think she did it. Yeah, we think that she committed this battery. Why would you think that? It's only because of what you heard. You didn't pick a side beforehand, so if you all go back there, yeah, we think she did this battery. Then it's because I met my burden. People have brought evidence which has overcome. We believe in the presumption of innocence, absolutely. But when it is overcome by evidence that's sufficient to convince you, we've met our burden. It's not a proof beyond all doubt, beyond a shadow of a doubt, to a mathematical certainty where you have to say, oh, are we 85, 95? We're not putting a number on it. Are you satisfied that one time there was an offensive touching against Ms. Drakeford's will intended by the defendant? Now, there's a couple other things that I want to talk about before I stop talking all of you leave, right? Both the victim in this case and the officer said that Ms. Jackson was angry over a parking spot. Both of them said that there was bruising to her face. Both of the officer said that there wasn't bruising to her face, and that's consistent with Ms. Drakeford saying that she did not attack her. The case is really simple when you take into account the jury instruction on assault and battery that the judge is going to give you. And it is a serious case. Maybe for the officer, it was just another day in Detroit, 1,000 more police runs. But for Ms. Drakeford, it's a day she will never forget. And so, members of the jury, go back in the jury room and bring back the only verdict that does justice in this case. It's justice for Ms. Drakeford, a verdict on count one, assault and battery, finds the defendant guilty. Thank you.
Members of the jury, The evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and the testimony, and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. Make sure that. Okay. You must take the law as I give it to you. If a lawyer said something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that she did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else that I may have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My rulings, comments, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, or suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. You have heard testimony from a witness that was a police officer. That testimony is to be judged by the same standards that you use to evaluate the testimony of any other witness. The defendant is charged with a crime of assault or assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on the complaining witness, Ms. Drakeford, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. Second, that the defendant intended to commit a battery upon Ms. Drakeford, or to make the complaining witness reasonably fear an immediate battery. The touching must have been intended by the defendant, that is, not accidental, and it must have been against the complainant's will. It does not matter whether the touching caused an injury. As used in these instructions, the word force and violence mean any use of physical force against another person so as to harm or embarrass him or her. The prosecutor must also prove beyond a reasonable doubt The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 17, 2018, within the city of Detroit, county of Wayne, at or near the location of 3236 West Grand Street. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Counsel approach. Get those off the print and give it to counsel. Okay. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please have your foreperson write a note. If you want to communicate with me while you are in the jury room, please have your foreperson write a note. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and pass it silently to the court officer. You can slide it under the door, you can open the door and pass it silently to the court officer. It is not proper for you to talk directly with the judge, the lawyers, court officers, or other people involved in the case about anything. If you need water, write a note. If it is too hot, write a note. If it is too cold, write a note. If you need something else, write a note. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside of the jury room. That means if you are deliberating and you cannot reach a verdict, you're talking, and 4 people say one thing and 2 people say another thing. And then you keep going. And 3 people say one thing and 3 people say another thing. And then you decide, we're not gonna be able to, nobody's changing their mind. You write a note to tell me, we are deadlocked, we cannot reach a verdict, but don't say 3 to 3, we can't reach a verdict. 4 to 2, we can't reach a verdict. 5 to 1, don't write any numbers in the information. Just let me know that you believe that you can't reach a verdict. I'm at 3.15 and it says they can ask for the exhibits, but there were only the 4 pictures. Are you all okay with me just sending those pictures back to the jury?
Yes, Your Honor.
Yes.
All right, so you're gonna get the exhibits to go with you. Additionally, when you go to the jury room, you will be given a written copy of these instructions that I have read from the beginning of the trial to now. As you discuss the case, you should think about all of my instructions together as the law that you must follow. And if you need to, you can refresh by looking at them. You may return a verdict in this case of not guilty or guilty. And the verdict form, which you all will have in your notebook, reads the people of the state of Michigan versus Shavante Jackson. And it says, we, the jury, in the above captioned case, by unanimous decision, find the defendant count one, choice one, not guilty, or guilty of assault or assault and battery, so say we all. The only person that needs to actually fill out their verdict form, if you read your verdict, is the foreperson. The foreperson will date, print their name, and sign their name. Each of you will have a verdict form, but only the foreperson needs to fill out their verdict form. That concludes the court's instructions I've read to the jury, 3.1, 3.2, 3.3, 3.5, 3.6, 4.3, 4. 5.11, MCJI 17.2, 17.14, 3.10, 3.11, 3.13, 3.14, I amended 3.15 to say that they would go back. 3.16 and 3.17 are the people satisfied with the court's instructions?
We are, Your Honor.
Is defense satisfied with the court's instructions?
Defense is satisfied. Thank you, Your Honor.
All right. It is now time for me to draw lots to see which two of you will be dismissed. And this is how it's going to work. I'm going to draw two numbers. And then you're going to write your telephone number where you can be reached. The officer is going to give you something to write your telephone number on, these two people. If the jury does not reach a verdict today, and if something were to occur where we needed to replace a juror because of an emergency over the weekend, because remember, we can't have court tomorrow. So it would be Monday. So these two numbers, I am releasing you today, but I am not discharging you from jury service. If we needed you to come in because some emergency occurred, then we will call you and you would have to report. I would draw between the two numbers, and then whoever number got pulled, then that person would have to come back. Court is going to thank but not excuse juror number 3. I started showing my numbers because I felt like something. Mr. Henderson.
Yes, sir.
The court is going to thank but not excuse what is me? That's the six.
That's it.
Juror number 6.
Yes, sir.
You can leave your notebooks in the chair. We're gonna lock them up. If you've taken notes, then if you are called, we will make your notes available to you. Your notes will not be destroyed until the jury reaches a verdict. And then they can get their vouchers. And then what I'm gonna do, your first order of business, when you go to the jury room to deliberate, is to tell me whether or not you're going to lunch. That determines if I have to leave a officer at your door. and then they have to switch off on their lunch. You are free to say, yes, we're going to lunch, but only for a half hour. Yes, we're going to lunch, we're taking a full hour. Yes, we're gonna go out and get something to eat. Everybody's gonna bring their lunch back and we're gonna deliberate, and so just give us 20 minutes. It's up to you in terms of the lunch break now, because it's however you wanna proceed. Okay, you can take her back now. If you are still deliberating at 4 o'clock, I'm gonna give you a break so you can go cash in your voucher. So if you deliberate up to that, I don't want them to close with you, not being able to cash your voucher. You're gonna get the book on. Everybody might not have the,
It's at least two.
but we don't know which two.
The
Sure.
And,
I made new copies this morning, so just took one out today.
I know, we're running out of work.
okay, so then, take the one from 4 and give it to, take the one from 3 and give it to 4. All right. Any questions before I discharge you to go to the jury room? All right.
All right.
Whether or not you took notes, take your notepad with you.
All right, Mr.
All right, anything before, oh, well, I'm gonna wait and see. And then, no matter what their decision is, I have an errand. I have an errand to run at lunchtime, so if they say they wanna work through lunch or whatever, that's fine, but if they send back a note, it can't be read until I get back, and it's gonna at least take, I'll be gone for at least a half an hour, so. This is case number 224539001, people of the state of Michigan versus Crystal Marie Nieves. The defendant is charged with 1 count of assault or assault and battery. Today's date set for pretrial conference appearance. Ms. Dees.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Kristen Yandis is here for review. Just can you? Oh.
This one, see. I could turn the camera on.
Oh, okay.
You didn't tell me to read that.
He wanted to say something,
You want what?
say something.
Ms. Nieves, unmute yourself and tell the court your name.
Hi, my name is Crystal Nieves.
Today's the day set for review and I received an update from probation that okay. According to probation, Ms. Nieves has not completed any of the terms and conditions of her probation. She, did I say this to you? Well, I'm gonna say it to you.
Okay.
Oops. She still has complete anger management choices, submit to a drug test, and pay fines, costs, and fees. She was placed on probation in March for 15 months, so this is her first review, I'm assuming. And then Mr. Hunter sent another email that says that he received a notification from an agency named the Demrock Center indicating that Ms. Nieves was completing some anger management through this agency. And when I asked if this agency was approved by the probation department, he said no. Ms. Stevenson?
Thank you, Your Honor. So Ms. Nieves did contact me to advise me shortly after sentence that she does not have any money to, she didn't have any money to participate in the eBay program. So she's on probation, as the court knows, for 15 months, hoping that her financial situation will change, and not wanting her just to do nothing. I did advise her to try to find some kind of anger management program to get into, which she did.
But why did you advise her that? Why did you advise her to get in an anger management program that was not approved by probation?
She's not paying for it, and because the only alternative at that point was for her to do nothing until she gets some money. So
No, the alternative was for her to contact probation, let them know that she feels like she couldn't afford eBay, that she found a free one, and to see if they could approve it.
Your Honor, I misspoke. I definitely misspoke. I didn't ask her to do that, or I didn't advise her to do that without speaking with Mr. Hunter. Ms. Nieves did tell me that she's been trying to make contact with Mr. Hunter, and that his response to her is that, makes sense to me, that the court's order is that she go to eBay, and that's on Catherine. So knowing that we have this review coming up now, again, not wanting her to just do nothing, she's over at the Denmark Center. Understanding that she still is under the order of the court to comply, to go to Choices and to go to eBay's anger management program. But I just didn't think it was wise for her to do nothing until this review. Ms. Yves has, through the Denmark Center, Your Honor, gotten some psychiatric treatment wherein she's been diagnosed with post-traumatic stress disorder. At her sentencing, did reveal to the court that Ms. Yves is a domestic violence survivor. And again, we just didn't think it was in her best interest to just kind of wait around and do nothing about trying to increase, to make her mental health better. So that's what she's been able to do. She understands that the court has not relieved her of the order to get counseling through eBay, but she felt like she had to do something before this review date, and that's what she's done. She's gotten 5 classes in addition to the group therapy sessions that are available. She does have individual therapy at her disposal. She doesn't have to pay for that counseling. The agency is approved by the court there in Roxbury, Massachusetts, where the court gave her permission to continue to reside. And again, it's helping Ms. Yves.
That's nice that it's approved by some other court, but I don't care if it's approved by another court. Ms. Nieves can only attend a place approved by 36th District Court. Okay. Now, I don't know why Mr. Hunter would say what he said. I don't know that. No one sent me any requests to say if I would agree to allow the person to go to a different place. Everyone who has anything to do with this court, meaning me, knows that I prefer eBay. I prefer eBay. eBay is not the only court-approved place. And if an individual is living out of state, then the only requirement is that the location, the program be approved by probation. So if they wouldn't be approved, if they were in the state of Michigan, then they're not gonna be approved in another state. I don't care what other court approved them. If it doesn't follow whatever guidelines are set by 36th District Court, then it's not acceptable. So her community, her anger management must be approved through 36th District Court, or it doesn't count. Why hasn't she done anything else?
I think the rest of it is financial,
You do?
I think.
So if she doesn't have any money, why haven't I been asked to convert it?
Don't. Maybe I missed, my notes aren't correct, but I think it's money. I think it's money, anger is the cost, the screening and the direction of the probation department, anger management and choices.
Right, so if she can't pay the costs, nobody has asked for community service. And I don't know how much choices is. And then why hasn't she submitted to a drug test?
I don't have a response.
My probation officer spoke to me about taking a drug test, but I don't know where to go exactly to do this.
All right, here's the thing. I freely give people permission to reside outside of the state of Michigan. However, please understand that residing outside of the state of Michigan is their issue. It is not mine. They need to work with probation to get things approved, or else they have to come back to the state of Michigan, where we don't have problem with the services that are being provided in the state of Michigan. So saying that I don't know where to go get a drug test because I live outside the state of Michigan is unacceptable. It's unacceptable.
I never got in trouble with the law.
It's
I never had to deal with this.
Unacceptable. It's unacceptable, and it's unacceptable for you to just talk in the court. Okay. Again, if Ms. Nieves is going to reside outside of the state of Michigan, then she needs to work with probation or you to figure it out.
Understood, Your Honor.
Otherwise, she's gonna have to come back to the state of Michigan. So let's figure it out. Let's figure it out. Let's get it done. But telling me that I live outside the state of Michigan and she's inappropriately dressed right now for court, I'm just letting you know.
Okay.
Okay, so,
Man, I have a
Ms. Nieves, please stop talking, Ms. Nieves.
sorry.
Talking, thank you.
well, because she has an excuse for everything, Ms. Stevenson. Let me tell you what I know. What conversation could there possibly be for the court to say, you're inappropriately dressed for court?
None.
It couldn't possibly be. It's just a statement of fact. It's a statement of fact that she's not properly dressed for court. Now, I haven't asked her to move back from the camera because her face is all the way up to the camera. We can barely see her face. We see in the top part of her eyes. All of that. I didn't say move back. Why? Because she's inappropriately dressed for court. And there is no conversation for that. Except, I apologize, Your Honor, and I'll make sure that I'm appropriately dressed next time. Let's get it done. Otherwise, that I'm not gonna continue to allow her to live outside the state of Michigan. Let's get it done.
Okay, Your Honor, Ms. Nieves and I do, keep pretty good contact with each other, so I will work with her more closely in making sure that she's working through probation. I can't do probation with officer's job.
And I don't want you to,
Right.
but she gotta work through probation.
Yes, and I'll, give her the assistance that I'm able to.
And
make sure that
let's
she-
understand, like I say to every person that comes in here, Mr. Hunter is one person. He has 5 supervisors over him, all the way up to the court administrator. He has 5 supervisors. If Mr. Hunter is not responsive, then I'm certain that Mr. Torres will be. If Mr. Torres is not responsive, then I'm certain that Mr. Wade will be. If Mr. Wade is not responsive, then I'm certain that Ms. Daniels will be. If Ms. Daniels is not responsive, then I'm certain that Ms. Crosby will be. If Ms. Crosby is not responsive, then I'm certain that the chief judge will be. It's no excuse for coming and saying, Mr. Hunter didn't call me back. It's 5 people over Mr. Hunter. So, anything further?
I do foresee a request to, convert some of the financial obligation over to community service.
All right, so let's talk to Mr. Hunter. Let's send an email, let's send a phone call. Clearly, I've given her permission to live out of state. So I don't have a problem converting fines, costs, and fees to community service, as long as we're gonna have a community service location approved by the 36th District Court, and she can complete her community service. Are you asking me to do that now, or you wanna wait?
Ms. Nieves, we haven't talked about this before, but you owe a lot of money to the court. Do you want to try to work some of that off? Want to do some community service to decrease some of that financial obligation?
Yes, ma'am.
Okay.
So according to Mr. Hunter, her balance, what is her balance, Mr. Planner?
$1,085.
$1,085. Of that, court will convert $875 to 87 hours of community service.
Right, thank you very much, Your Honor, and, I guess I can call you in a couple hours to walk through this, okay?
I don't know if she heard you. Did she hear you?
Ms.
I
Nieves,
can't, yeah,
okay, I'm gonna call you in a couple of hours, so we can talk about this, okay?
okay.
All right. Thank you very much, Your Honor.
All right, you're welcome. Have a great day, ma'am. Stay safe.
You too.
Oh, wait. No, I'm sorry. I need to give her another date.
Excuse me.
So she's on a 15-month probation. She was put on in March. This is July. That was 4 months. Let's come back in 6 months.
So can we come back earlier in case there's a problem with that approval?
No, I mean, if you need to come back early, you
Okay.
can come back early.
Okay.
January 20-something. Look up is that a weekday, the 27th, January?
Nope, it's Saturday, so 29th, that Monday.
The 29th, January 29th, 10 o'clock. January 29th, 2024 at 10 o'clock. Have a great day, stay safe. I'm ready on cribs. Case number 194473001, the People versus Reginald Cribs. Defendant is charged with operating while visibly impaired. Today is the day set for review. Mr. Cribs, I said you didn't have to come, and then Ms. Stevenson, who will do whatever she wanna do, she said you coming anyway. I mean, I just show up here for work. How you doing, Mr. Cribs?
Okay, how you doing, Your Honor?
I'm all right. Mr. Cribs, she said you had something you needed to say.
Yeah, I just wanted to thank you guys for, giving me the opportunity to start over again.
You're welcome, Mr. Cribs. You're welcome.
Appreciate
You
it.
have completed all the terms and conditions of your probation. Great job. So I am going to discharge you from probation with improvement and close your case out. Congratulations to you and good luck to you in the future, okay?
Okay, thank you once again. Thank you, Your Honor. I appreciate you.
No problem. You're welcome. You have a great day and stay safe.
Okay, you too.
All
Thank
right.
you. Okay, thank you.
All right.
Bye.
Thank you.
Officers in here. I'm like literally in here by myself. They could be in here beating me up. I got you. Okay, well, are you gonna get the part of the paycheck that belongs to security? I don't know. There's literally no security in here. All right. Well, let's call for security and then.
We talked about Katrina Bryant.
Yes, because she called yesterday.
Oh, did she?
Yes.
Yeah, and I bet you just want to get a resolution.
Yeah.
Yes, to Mr. Flanagan. Need some guidance. So just, she was last here on June 21st.
Actually, she failed to appear on June 21st.
Oh, that's right. She was last, she was scheduled. That's exactly right.
Okay, so did she go to appear with them? I didn't get this.
No, you wanted me
That's
to
right.
wait to hold off.
Why? Cause Miss Stevenson had begged me for something? Miss Stevenson did, okay, but did you give me the reason? I mean, I need to look at my notes, but that don't sound right.
Yeah.
What were you supposed to do?
So my note is that she had problems zooming in on 620
And
and the status.
did I agree?
I don't know that.
Miss Stevenson, why y'all keep on letting, why you keep letting the building clerks pump y'all into doing these orders? Why y'all keep doing that?
I can only get so many emails and phone calls.
Y'all just let people pump y'all in doing stuff that you know you don't have to do. I'm not signing this one either.
Okay.
Y'all left me in here by myself with the people. Y'all just left me in here unprotected. Miss Stevenson in here doing stuff. So I'm confused by this right here, that she sent me. I'm a little confused, okay. So help me understand that I said, 30-day delays, okay. How can they say? Y'all give me something. Oh, okay. Here you go. I'm not signing this one.
Okay.
The paper that y'all wasted. And the note that you left for Mr. Flanagan. Look at the note that you left for Mr. Flanagan.
I'll just.
This sticky note that you left for Mr. Flanagan.
I'll say our request denied.
I'm ready.
All rise for the jury.
You all can always be seated. You all may be seated. So I received a note from the jury, and when I received the note, I said, they didn't read my note. Somebody didn't read my note. So the note wasn't in an envelope, because somebody didn't read my note, but nonetheless. Who's the foreperson?
I am.
All right, please stand. I received a document that I must believe is the verdict form. All right, Ms. Jackson, please stand. And you can get this back to juror number 1. And juror number 1, I want you to please read the verdict form for me, beginning with the sentence, "We the jury."
Yes, ma'am. We, the jury, in the above captioned case, by unanimous decision, find the defendant guilty of assault or assault and battery. Date 7/27/23. Floor person.
Don't say your name. Don't say your name. Thank you, though. While you're standing, though, Mr. Foreman. Was that and is that your verdict?
Yes.
You may be seated. Juror number 2, was that and is that your verdict?
Yes.
Juror number 4, was that and is that your verdict? Juror number 5, was that and is that your verdict? Juror number 7, was that and is that your verdict? Juror number 8, was that and is that your verdict?
Yes.
Ladies and gentlemen, thank you so very much for your service. Please return to the jury room. Thank you. I will be in shortly to speak with you. All right, Ms. Jackson, the jury has found you verdict. The jury has found you guilty of 1 count of assault or assault and battery. I therefore adjudge you guilty of 1 count of assault or assault and battery. Out of your presence, Ms. Stevenson, off the record, the prosecutor had asked me a hypothetical, and he said, if the jury did come back with a verdict of guilty, would I be sentencing Ms. Jackson today? My response to him was that of course, it depends. And the complainant is here, the victim is here. So she would have an opportunity, should she choose to make a victim impact statement. But would you like for me to do a pre-sentence investigation, or would your client be prepared to receive sentence today?
We would ask for immediate sentencing.
Okay. All right, then the jury having found Ms. Jackson guilty of assault or battery with respect to sentencing, is there anything on behalf of, I'm sorry, Mr. Henderson, please forgive me. You asked that question, but you didn't say what your preference would be. So I apologize. Would the people have any objection to immediate sentencing?
We would not, Your Honor, and since Ms. Drakeford is here, we believe it's appropriate at this time.
Okay, and then that being the case, is there anything on behalf of the people with respect to sentencing?
Your Honor, we would request that Ms. Drakeford be given the opportunity to give a victim impact statement.
Yes, you may. Ms. Drakeford, would you like to give a victim impact statement? Okay, Ms. Drakeford declined to give a victim impact statement. Anything on behalf of the people?
Your Honor, I would just remind the court of her testimony at trial, and also my strategy in trying the case was to keep it simple for the jurors. Ms. Drakeford did indicate that the fall, where she fell over a bike and a box, and that she's had lingering injuries from that. So there was the pictures that, I don't know if the court saw, I was gonna say that the court saw, I don't know if
I didn't see it. It's a jury trial.
And, I don't know.
Did you want me to see?
I would like for you to see them and take that into consideration in your sentencing, Your Honor.
Officer, can you all go in the jury room and bring me the exhibits, the pictures? Thank you.
But in addition to that, Ms. Drakeford testified that she has had residual pain in her back and in her back and her thigh, or struggling to remember the word that she said, but her hip area, she's had residual pain from that. It wasn't just the bruising, and we would ask the court to take that into consideration. That was part of the incident, and so we would ask the court to take that into consideration with sentencing Ms. Jackson.
Okay. Anything on behalf of the defense with respect to sentencing?
So on behalf of Ms. Jackson, Your Honor, she has exercised her right to remain silent, Your Honor. She does, through me, express remorse for the entire situation, not accepting any accepting the jury's finding 100%, but her position remains the same. But she is remorseful about the entire situation.
One second.
Yes, Your Honor.
I just saw him walking kind of away. His name is Mr. Evelyn, if I'm seeing him with my eyes correct. Thank you. Mr. Evelyn.
Remains remorseful about the entire situation, Your Honor, and is absolutely ready to accept the sentence of the court. This situation has been lingering for some years. Ms. Jackson is very anxious to put the entire matter behind her. She's not living at the location, and actually Ms. Draper didn't live there anyway, so there's no reason for the parties to have any contact with each other. And I think that she's gonna lean into whatever the sentence of the court will be and just try to move forward from this.
Ms. Jackson, you exercised your right to remain silent during the trial. You do have the right to speak now. Do you want to give any statement at this time?
Actually,
You didn't catch him?
he said, yeah, come back and say.
Oh. I'm listening, Ms. Okay.
I didn't try so hard, so my emotion the whole time about this trial. At the time this incident happened, I was pregnant with my son. Not only did I was pregnant with my son, my private property at home. This woman attacked me. And when I go to up me, I'm here 5 years later in court about an incident that I didn't attend, I didn't hurt the lady or anything. I was closing the door, trying to follow the rules to my unit. My son stayed in ICU for 2.5 months. It's been time where I didn't think he was gonna make it home. And here I am, she's the victim. I just feel so, I have a lot of emotions within inside me about this whole thing. I did not just hit no woman or beat or do anything. I just.
You have some Kleenex in? It's not.
I can get it promised.
Okay.
It just hurts so bad.
Hold on, your lawyer is leaving the room, so hold on one second. Okay, you can continue.
It just hurts so bad when you know you're not guilty and it's just still. I just don't even know what to say about this whole situation. I regret the fact that just regret the fact that he was bumping into her. That's all I have to say.
Okay. All right, so. Court has sat through twice now. This trial. And what I will say is that, of course, having sat through twice this trial, we can clearly see how individuals can see the same situation differently. Okay, we see how individuals can look at a situation and see it completely different. Of course, in a jury trial, it's never my place to determine or have an opinion, well, express an opinion about the facts of the case, as I read over and over in the jury instruction, that's up to the jurors. Now, what we know is that on the last time you were tried, Ms. Jackson, 5 people thought you were not guilty. And 1 thought you were guilty. Huh? It was the other way around. I thought the one man said you sure?
Well, that's the information
That I gave you all. I remember that one man was the holdout, but I thought he was the holdout in favor of Ms. Draper. Anyway, because now I'm second guessing my own self, I don't remember. And so on this occasion, all 6 of the jurors called the other 2 jurors, let them know they're released. We gave them their thing. Oh, Officer Grass has it. On this occasion, the 6 jurors have found you guilty. These are my observations. I believe both of you need to take a chill pill. I believe it. I believe that Ms. Draper is so angry that had cooler minds prevailed, we wouldn't be here. But I also believe, now having seen these pictures, and I don't know who attacked who, and I don't know why Mr. Few wasn't presented in the first trial. But what I know is that there's a lot of embellishing. There's a lot of embellishing going on. What I know is that over the course of time, the thing has increased. It magnified. So Ms. Draper's perspective has changed and magnified over the course of time. I don't understand why Ms. Draper insisted on coming through the door. And I don't understand why you insisted on her not coming through the door if Mr. Few was standing right there. And I don't understand why, if Mr. Few was standing right there, he wouldn't have just spoken up and said, this is my guest and she coming in here. So somebody not being honest, because that don't pass the smell test. Now, what perhaps could have occurred is that Mr. Few had gone into the apartment, because my mother used to live in that, one of them same kind of 4-family flats. I'm very familiar with it. And was Miss Jackson supposed to let Miss Draper in without her guest being there? Absolutely not. And it seems to me that all Miss Draper had to do was to step back, let the door close, and then Mr. Few would have came and opened up the door. But that didn't happen. And the reason I said you're angry is because I know you have something to say. But your anger overtakes you so much that you were irritated with my questions. You were irritated with the way I've done my job. You were irritated with the way Ms. Ritter did her job. You were irritated with the way the police officers did their job. You've been irritated with the way that everybody did their job. And I am observing that you might have been irritated with the way Mr. Henderson was doing his job, because I saw you standing in my courtroom talking to Mr. Henderson in a way that I didn't like. And that's why I said you all need to go in the hallway. You had an opportunity to speak to the court about the impact of this on you, and you chose not to. You had an opportunity to speak to the court about what punishment you think is appropriate, and you chose not to. You had an opportunity to speak to the court asked the court for restitution or whatever it is you thought you were entitled to, and you chose not to. And the reason you chose not to is because you're angry. And I can order Ms. Jackson to do anger management, but I can't order Ms. Draper to do anger management. And I believe that if you both had taken an opportunity to allow your reasonable mind to dictate the situation, you wouldn't be here today. Ms. Jackson, it was not important. It wasn't as important as all that you've been through, 2 trials and now the guilty verdict. Now, you spoke to me with passion, with conviction, with whatever. And then for whatever reason that you chose not to give your story to the jury, that's your business, that's your decision. I don't know if it would have helped you or hurt you, because I don't know what they were thinking, you know? So I don't know if that would have helped you or hurt you. But now we're here today and I'm looking at the pictures that was presented. This is the first time I'm seeing the pictures because again, it's a jury trial. I don't know who hit who first. Ms. Draper said her foot was over the threshold and then you pushed the door. But there is a huge scratch on Ms. Draper's chest. And I believe, and I won't know this until I go back there and talk to the jurors, I believe that's what they might have taken into consideration in delivering their verdict. So we are here and sounds like your son is fine.
Yeah.
I'm glad he made it to this point. Court is going to impose the following sentence. I am going to impose a probationary period of 12 months. That places a final review date in July of 2024, but I don't have my calendar. So you'll give me the date, and then I'm gonna give you a halfway review date for 6 months, so I need 2 dates. I think the 6-month date is January, and I think it was January. I'm gonna make your review date January 30th. That's the 6-month mark, and that will be the mark where you will be eligible for early discharge. What's the 12-month date?
July 29th.
July 29th, 2024, if you have to go the full 12 months. I impose the following terms and conditions. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without the consent of the court. You must make a truthful report to probation. Strike that. I'm gonna make your probation non-reporting. But Ms. Jackson, sometimes that's harder, right? So if you're not self-motivated, then you might not be able to get discharged early because you're gonna come at 6 months. And if you haven't done anything, you're not gonna get discharged early. So it's gonna be incumbent upon you to make sure that you're gonna do the other things that I'm gonna order you to do. I am gonna order that you pay the mandatory cost of $210. I am going to impose a $300 fine. No supervision fees and no assessment fee. Despite the fact that Ms. Draper chose not to speak to the court for some reason unknown to me. I'm going to, let's change the review date. I need a 3-month review date. I need a 3-month review date. So that's gonna be, I think, October. So because notwithstanding there being no mention of it or request of it today from the complainant, she would be entitled to restitution for any out-of-pocket expenses directly related to this event. So I'm gonna set a restitution hearing and review for 3 months, October 27th, 2023. Ms. Draper has until that date to either turn over to the prosecutor's office or the probation department any claim of restitution. Let me say this as it relates to restitution. I do not believe that her injuries were as serious as she testified to. Do I believe she had an injury? Absolutely, I do. I do. Do I believe it was as serious as she said? Absolutely, I do not. I do not believe that all that surgery and all of that. The only way I'm gonna, if she had out-of-pocket expenses as relates to that surgery, the doctor has to tell me that that surgery was a direct result of her falling on that bicycle that she said she fell on. All right. Otherwise, I'm not ordering it. Now, I can clearly see she has a big gash across her chest. It sounds like the jury, well, I don't know, they might just be going by this, but there was some testimony that she was hit in the head. Do I believe it was 40 times? I do not. And do I believe it lasted for 15 minutes? I do not. Do I believe that if she was getting beat for 15 minutes, her friend would have called the police? I do. So there was no concussion or nothing that day notated. So I will order reasonable restitution based on the injuries that are reasonable. I am going to also order a $100 attorney's fee. So the restitution is to be determined. The total fines, costs, and fees at this particular moment is $610. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription, letter of explanation from the doctor. You shall not drive without a valid driver's license. You shall attend 12 weeks of anger management through eBay. And if you have any outstanding tickets with 36 District Court, you need to pay them. If you have any outstanding warrants, you need to take care of them. I'm gonna ask you a question. I want you to be completely honest with me, okay? Do you take any drugs, marijuana, cocaine, coke, anything? If I send you over for a drug test today, what are your results gonna be? Okay, I want you to take a drug test today. If I'm satisfied with the results, then I won't order you to test monthly. If I'm not satisfied with the results, I'm gonna have you test at least once a month up until that first review, so I can see if I need to send you to one of our specialty courts, okay? All right. You are to have absolutely no contact with the complaining witness. I'm not gonna order the choices program right now. However, I'm gonna tell you this, if you look like you're struggling on this probation, it look like you need a little bit more intervention, because I'm gonna tell you, you angry too. You angry and you mad that this whole thing happened. You're angry, you believe you're the victim and that you were the one charged. I don't know what happened. It's only 2 people in this room that know what happened that day. There are only 2 people. The rest of us, we're piecing it together, trying to figure it out, looking at what you all say, what was presented, we don't know what happened. You could be right. You could be the one that was attacked. We don't know. We know what was presented. But what I need you to do is, even if that's true, if you were the one attacked, but you got charged and now convicted, you need to learn how to let that go, because you're raising a child. You don't want the residual anger and bitterness and all of that to transfer into you raising your child. Mr. Rice is gonna really be able to help you with that through his anger management program. It is a phenomenal program. The defendants have come and gotten off probation and continue to go see Mr. Rice, which is why I prefer that program. I'm not gonna order you to do choices unless it looks like you need some extra assistance in making choices, making the right choices, learning how to walk away from somebody who's trying to get in your apartment and then just going into your apartment, and if you needed to, calling the police. Because if you had done that, you wouldn't be here today, okay? I just need you to be more mindful of that. I didn't do a pre-sentence investigation, therefore, Ms. Stevenson, I need you to check with Mr. Flanagan to make sure we have the current address and phone number. It looks like Ms. Stevenson has given you the information for eBay, so you contact eBay, and then I'll see you October 27th. If there's any restitution, because here's the thing, and I know I said probation or the prosecutor's office, but I didn't do a pre-sentence investigation, so probation is not gonna reach out to Ms. Drakeford. So if Ms. Drakeford has anything that she wants to present in terms of restitution, then I need that presented to the defense before October 27th. And then, so that they can, I can have it on the 27th.
Yes, sir.
Okay. All right, anything further with respect to Ms. Jackson?
Can I just get, you said eBay?
eBay, Ms. Stevenson can give you a card.
Okay.
Mr. Rice runs several programs. I've never met Mr. Rice in person. I've only met him one time on Zoom. And that's only because the defendants rave about him. People have come in here so angry and came back smiling, saying how wonderful Mr. Rice was. So I love the program. The defendants, when defendants are happy about a program that has changed their life, I'm willing to always give them a try, which is why now he has a waiting list, because I keep on making everybody love Mr. Rice. Okay, I'm gonna go back and talk to the jurors and let them know that they are free to now speak to you if you want to. If you want to speak to them, I'll send message through the officer. You can wait on the second floor by the cashiers. That's where they're gonna be.
Can I just do one thing? Judge?
You may.
So prior to this, I don't believe that Ms. Jackson had any criminal history. This is her.
Why are people on YouTube talking about my sentencing? I'm here ready to talk to the people on YouTube now. Turn the camera around. Let me turn the camera around. I'm coming. Oh, hi.
I was just trying to grab a form.
Oh, okay. I'm talking to the people on YouTube. I'm gonna call these names out too. Hold on. Kirk. I'm talking to Kirk. I'm talking to, I look like I'm just talking to Kirk. Oh, no, I'm talking to, I'm a Miracle. That's why y'all the reason I be shutting down the chat. I don't care what you think about what I'm doing in here. Don't nobody ask you for your opinion. That's why you're not the judge and I am. If you want to make the decisions, go to law school and become one. So now I'm getting ready to turn off the chat. Hold on. You're welcome. Good to see you, Judge. See you too. Well, I'm turning it off. Sometimes I'll be letting it on when I have a jury trial. They didn't get too far now. I'm turning it off. All right. So if you want to talk to the jury, you can go down on 2 and I'll send message to the officer whether they said yes, they want to talk right now. Okay?
Oh, okay. I would like to talk to him for sure.
Okay, I'll let them know. What's that?
So I did have one more thing for the court. I was taught Ms. Jackson, prior to this conviction, had no criminal history that I'm aware of. This is her case file. Ms. Jackson and I have been working long, hard, and strong on this case, Your Honor. She is employed. She is a mother. She is concerned about keeping a clean record. I believe that she's gonna go ahead and do what you ordered her to do, Your Honor. The case is old at this point. She's exercised her constitutional right to take this all the way to jury trial. She's accepting the jury's verdict, and I am asking the court to consider sentencing her pursuant to 771.1 so that she can have an opportunity to keep a clean record.
And my response is, I will consider it at the halfway point.
Okay,
That's my response.
okay.
If what you say is true, then she shouldn't have an issue. I'll consider it at the halfway point.
All right, thank you so much, sir.
All right, you're welcome. All right, I'll be back. I'll send a message to the officer. All right.